Live stream audio test, 1, 2.
Well, good morning, ladies and gentlemen. It's 9:30, so the inquiry is resumed. Fresh attendance list, just checking that there is one circulating, thank you. And if you've got a mobile phone with you, please make sure it's switched off or on silent whilst the inquiry is sitting. Thank you. Well, I'll be hearing closing submissions shortly. Before I do, I'm just going to check if there's anything from either of the parties. But even before that, I just need to say that when I looked again at the copy of the Section 106 that had been handed to me, I see it says on the front, please do not date, and there's no signature in it from the council. I've no reason to believe that it hasn't been completed. I've been told it has, but the document I have doesn't actually confirm that.
Well, sir, we have signed it. I believe it has been completed, but Bernard can confirm that.
My understanding, Natalie, do you want to set it out from the council's perspective? Thanks.
Yes, so they were brought to the inquiry on Monday. They were delivered to our solicitors up at our other offices yesterday. They're being signed today. I'm happy to send an email round to confirm when that has been done, but it is agreed and will be signed today.
Right, okay. So the version I've got with the please do not date on the front isn't actually a very helpful one for me to have.
I will confirm. I assume it will have today's date on it once signed, but we'll confirm that again by email to everybody.
Take it off, sir, and send you the copy that you actually
Yes, I was going to say, you might as well have this one back. I know that it's all in hand from what I've just heard, but clearly a final version would be appreciated. So yes, if I can let you take that one back. I mean, it can either, if it's available before I close the inquiry, then let me have it. If not, then as long as a copy is sent on to the inspectorate within, well, it should be almost immediately, but let me say within 7 days, that'll be fine.
So it can't be provided today. It will be sent, and you'll have it within 7 days.
That's fine. Thank you. Thank you. So, is there anything then from either of the parties before I ask to hear the closing submissions?
You received electronically, sir, the note you asked for on the local planning authority's position on biodiversity and ecology. You don't need a hard copy, do you?
No, I've got that one, thank you. Yes, and I got an electronic copy of the latest version of the conditions, so that was fine.
Did you have a hard copy of the addendum statement of common ground on housing supply? I think
I've got one that I printed off, yes, so I'm happy with that as well.
One very minor but nonetheless relevant point for your list of appearances is you might have picked up in the planning press that Ms Ventham's, and indeed Mr Quartermain's firm, Barton Wilmore, has been acquired by a company called Stantec.
Yes.
So that they're now described as Barton Wilmore, now Stantec. And so I've been asked if in the list of witnesses they could be described.
I will include
Barton Wilmore, now Stantec.
in that form. Yes, I saw it.
It's on the statement of common ground. So.
I saw it on the latest correspondence that came through. Yes.
Thank you.
That does just remind me, just going back right to the start of the inquiry, I did ask for the abbreviated forms of professional qualifications for Ms Richards and Mr Thorne and Mr Muston. Now, it's a long time ago now. I can't recall whether they were handed in.
So I thought I'd done that, but let me make sure that before you go, we do that for you.
Yes, thank you. I'm not saying you didn't, Mr Leader. What I'm saying is just suddenly, with Mr Banner mentioning a change there to the appearance, it just struck me that I recall mentioning that in opening, and I'm afraid I can't recall whether or not that was addressed.
Well, if Mr Banner will forgive me, what I will do while he is closing, in addition to listening very carefully, is just prepare that short note.
That's great. No, that's helpful, thank you. So, Mr Banner, you've raised that. Now, none of the interested persons who spoke earlier have indicated that they wish to make a closing statement, and the council has confirmed through the inspectorate's case officer that as far as you're concerned, there's no other party who wants to close. Final thing I should say, I did go and look at the site again. Yes, I didn't enter the site. I viewed it from Moor Road and from Moor Road and the surrounding area. So, on that note then, Mr Leader, can I hear the closing submissions for the Council?
Yes, and I've handed a copy to my learned friend of his planning witness already.
Thank you.
And the reason for that, sir, is a little way into my submissions, I do what I often do, which is make a few fairly trite statements of law, and there's authorities cited, and I don't print them off because, quite frankly, it's hundreds of pages that you then don't refer to. I gave them to my learned friend so he could check whether he needed them. He doesn't. If you need them, sir, plainly, I'll give you a copy. Thank you, sir. Right. Well, I set out at in the first paragraph the 5 main issues. They're familiar to us, so I won't read them out. I don't think it helps to extend things in that way. And I move straight away to the first of those issues, which is the harm we say will be caused to the rural character and appearance of the former orchard and the rural setting of Yatton. And the first point to observe is that this issue arises from an allegation that the proposed road would result in the unacceptable loss of trees, hedgerow and habitat, and would have a detrimental impact on the rural character and appearance of the former orchard and rural setting of the village, contrary to policies, amongst others, CS5 of the core strategy, DM10 and DM32 of the Development Management Policies, Sites and Policies Plan, Part 1. Now, that reason for refusal does not allege a landscape objection per se. The issue is whether the orchard is characterful in its own right and makes a positive contribution to the setting of the village, and whether that would be harmed by building a road across it. So, what is the character of the orchard and how does it contribute to setting? Well, the orchard does possess a particular character which contributes to the setting of the village. The veteran apple trees are set on the sloping land of a small paddock that rises from Moor Road and are viewed against the backdrop of the listed Grange farmhouse with which they were once associated. The land is clearly visible at the gateway to the village from Moor Road, approaching from the north. The Moor Road frontage is tightly enclosed by densely planted hedges and trees, and by dint of the lie of the land, takes the form of a sunken road, which in the summer creates an attractive Arcadian tunnel. The north-east edge of the site is bounded by the Stowy Rhin. Mr. Muston describes this varied agrarian landscape as a timeless pastoral scene, which harks back to the village's agricultural past. That is a fair and accurate description. It is also a character that is valued by local people. Turning to the impact of the scheme on character and setting, the appeal proposal will harm the appearance and character of the site. The Arcadian character of Moor Road will be disrupted by the grubbing up of hedges and trees along Moor Road. The orchard will cease to be a self-contained vestige of the village's agricultural past, clearly associated with the Grange farmhouse, and will instead be severed from it, creating an incongruous area of public open space which is neither connected with the Grange or the new houses that will be built to the north. Its historic character will have been eroded, and whilst it will still sit at the gateway to the village from the north, that function will be diluted by its nondescript appearance. Now, the appellant rejects this characterisation. It places great store on its landscaping proposals, which it says will result in the planting of a new orchard. Now, there will be more planting. However, the result of driving the road up and across the orchard means the scene will appear suburban rather than rural. It really does not matter that the site is not highly visible in the landscape. The contribution of short-range oblique views across the site is not diminished by their enjoyment at close quarters as a cyclist or walker rounds the bend at the entrance to the village. Nor is it relevant that the orchard occupies a small area of the Kingston Seymour and Puxton Moors LCA. Setting to one side the absence of any landscape objection per se, were that a valid approach to assessing the impact of a scheme, no development could ever be found objectionable by reason of its impact on the character of an area. The harm that is caused is a matter of some importance. Policy CS5 requires that the character, distinctiveness, diversity and quality of North Somerset's landscape and townscape will be protected and enhanced by the careful, sensitive management and design of development, with close regard being paid to the national character areas, landscape types in North Somerset's 31 LCAs. Policy DM10 then further requires development to respect the character of the historic landscape, including features such as field pattern, water courses, drainage ditches, stone walls and hedgerows. Where some harm to local landscape character is unavoidable, but a development is otherwise deemed beneficial. Now, in a similar vein, DM32 requires the design and planning of development proposals to demonstrate sensitivity to local character and the setting and enhance the area, taking into consideration existing context. Design solutions should therefore enhance local distinctiveness and contribute to the creation of a sense of place and identity. Now, for the reasons given by Mr. Muston, the suburbanisation of the orchard would erode the character and distinctiveness of the orchard, which would in turn erode the diversity and quality of Yatton's historic rural setting. That would conflict with policy CS5 and DMP 32. Moreover, because that harm could be avoided by taking in access from Grange Farm Road or the rugby club, the scheme also conflicts with DM10. Turning next to impact on ecology, the ecological importance of the appeal site stems principally from its close proximity to the North Somerset and Mendip bat sack, which hosts a significant population of greater horseshoe and lesser horseshoe bats. The Grange is used as a night roost by each species. They also forage along the hedgerows that bound the site, notably along Moor Road, Stowey Rhin, and that which divides the northern and southern fields, each of which are characterised as important under the hedgerow regulations. An additional feature of particular ecological importance is the remnant traditional orchard in the southern field. This is a habitat of principal importance for nature conservation and a UK Biodiversity Action Plan priority habitat. Its value is underpinned by the presence of 6 veteran orchard trees. Whilst the future lifespan of each of these trees is limited, they provide valuable deadwood habitat, and one is host to the rare orchard tooth fungus. That is a very rare UK Diversity Action Plan species, which is known to be grown to only 20 locations in the UK. Now, when the inquiry opened, there were 2 principal differences between the parties. Firstly, whether the proposals would have an adverse effect on the integrity of the SAC, and secondly, whether the scheme would result in biodiversity net gain. During the adjournment, Natural England confirmed as accepted the conclusion of the Shadow Habitat Regulation Assessment that the scheme will not have an adverse effect on the integrity of the SAC. That outcome is achieved by the provision of additional habitat on site to offset the loss of foraging habitat for lesser and greater horseshoe bats, and reflects the agreed position that less than 1% of the SAC population use the Grange as a roost. Turning to biodiversity net gain, the parties further agree that based upon plans Y12 to 14, February 2022, I'm going to summarise this in plain English. There is a shortfall, but that shortfall can be made up by off-site provision secured by granting condition. So, turning to paragraph 13, in the circumstances, Mr. Phillips accepts the appellant has now demonstrated the appeal proposals would not have an unacceptable impact on ecology. He also concludes that the scheme has provided all that is reasonably achievable to compensate the impacts of the road. Thus, although he considers more ecological benefit would be obtained from a different scheme, which avoids any development on the southern field, the correct test is whether the ecological impact of the scheme that we have is acceptable, not whether another scheme might achieve greater biodiversity. That approach is reflected by policy CS4 and DMP policy DM8. They require that a proposal should protect and enhance biodiversity in North Somerset, protect and enhance important habitats, and promote achievement of net gain where possible. The proposal furthers those objectives, I should add there, as far as possible, by protecting the qualifying features of the SAC and by securing biodiversity net gain. On that basis, the Council accepts the scheme complies with each of those policies. 5-year housing land supply next. On the 23rd of March of this year, the Secretary of State published an updated affordability ratio that has increased the housing requirement to 1,492 dwellings per annum, including a 5% buffer, that is, which produces a requirement of 7,308 houses. The result is that the council now contends it can demonstrate a 5.2-year supply of land for housing. The appellant argues the correct figure is 3.1 years. You're invited, sir, to find the council's assessment of supply is most likely to be correct. The core strategy focused on securing the regeneration of large, complex brownfield sites within the western urban area and the western villages. Taken together, they account for around 61% of housing land allocations in North Somerset. The western villages, in particular, required substantial land reclamation and master planning for the coordinated delivery of road, drainage and green infrastructure associated with the creation of balanced communities, including retailing, employment and social facilities. Consequently, the western villages and other challenging town centre sites were programmed to deliver most new homes in the latter part of the planned period. In the interim, supply was always likely to be constrained. However, the tide has begun to turn. Output from western villages has increased substantially in recent years. The housing delivery test result, published in January 2021, was 81%. In January this year, delivery increased to 89%. In 2021-2022, the number of homes delivered exceeded the number of homes required, and that is because the council is granting more planning permissions, whilst the local planning authority must produce an action plan to indicate how it will do better. The trajectory is positive. So the council's also realistic. Until the publication of this year's housing delivery test result, the authority was prepared to concede it could not demonstrate a 5-year supply. That position changed when it ceased to be obliged to apply a 20% buffer. The appropriate buffer is now 5%, and that is significant change. Appellants are apt to characterise North Somerset's output of housing as one of significant under-delivery, lending weight to the imperative to bring forward more land to improve the prospect of achieving the planned supply. However, that characterisation is inappropriate where a 5% buffer is applied, because by definition it only relates to authorities which are required to apply a 20% buffer. The council recognises it cannot relax its efforts to bring land forward. There is not and cannot be any room for complacency. Compared with recent years, though, the improved balance between need and supply indicates the weight that is to be given to the environmental dimension of sustainable development in North Somerset ought to be maintained, notwithstanding the importance that such a state attaches to its social and economic benefits. So turning to the detail of the 5-year supply calculation, the 5-year requirement having been agreed, the parties contest the number of houses that are likely to be delivered by each category of site. The deliverability of disputed sites and the timing and amount of housing each is likely to deliver was discussed at length during the round table session. So if I may just add a sentence here, and you don't need to write it down, I don't think, it's simply this. It used to be the fashion for advocates in closing to run through each site. And you did indicate, I think, so that you didn't require that. So what I present to you now, so is a summary position rather than seeking to persuade you about each site, about which you heard lengthy evidence, and I don't think it helps for me to simply trail what my side had to say yet again. So in the summary form, so I now continue, you have your notes of the evidence that was given. As I've just said, there's nothing to be gained by merely restating what was said by Mrs. Richards about individual sites. Instead, focusing on the summary position, the appellant contends the LPA overstates delivery by the following amounts. I then set out what I believe to be the correct difference between us, and it amounts to a total of just under 3,100 dwellings. Now, that summary indicates the key to establishing a 5-year supply turns on the question of who is right about the deliverability of strategic sites at western villages, large sites without land planning permission and development plan allocations. Taking the western villages first, Mr. Patterson-Nield and Mrs. Richards ought to be commended for the thorough way in which they examined the evidence of the deliverability of these sites. What each said deserves to be treated seriously and with respect, On balance, however, you're invited to prefer the evidence of Mrs. Richards. She possesses the unique advantage of a long-term, close and detailed involvement in bringing forward sites at Western Villages through her sustained and detailed collaboration with developers, landowners and their agents. She has led the year-on-year increase in output from this category of site. She understands the issues that affect each site, how and when they're likely to be resolved, and the timing and rate of delivery. She's also been willing to make sensible concessions in accordance with the evidence. Her judgments on the likely future performance of strategic sites are, I would suggest to you, sir, most likely to be correct. Mrs. Richards also leads on the delivery of large sites with outline planning permission and allocated sites. They were each the subject of very detailed scrutiny during the round table session. However, the key point that needs to be made is that it is not necessary to demonstrate with certainty that a site will be delivered, only that it is deliverable. In that context, it ought to be recognised that Mrs. Richards' long involvement in improving North Somerset's 5-year supply has given her a thorough knowledge of the issues that affect each of the contested sites and the likelihood that they will be resolved. She has not hesitated to exclude sites that she considers are not deliverable. Her evidence is fair, reasonable and balanced, and it can be trusted. And for those reasons, you're invited to conclude that on balance, the Council is able to demonstrate a 5 years supply of land for housing. If I could just add a sentence there, sir. Mr. Patterson-Neild was an impressive witness, but he just doesn't have the sustained day-to-day involvement. And it's that day-to-day involvement in all of the sites that we are concerned about that I would invite you to conclude gives Mrs. Richards the edge in a battle between two very good experts. So, moving next to whether policies which are most important for determining the appeal are out of date, irrespective of whether the Council can demonstrate a 5-year housing land supply. The appellant argues that policies CS 13, 14 and 32 are policies which are most important for determining this appeal. Its purpose is to trigger the tilted balance if they're shown to be out of date, and so I say that is a bad point. The reasons are the requirements specified by policy CS 13 and the spatial strategy of CS 14 are part of the strategic planning policy framework that led to the allocation of the appeal site under policy SA1. However, they are not important for the purpose of determining this appeal. Neither is mentioned in the reason for refusal, neither is contested. They do not even bear directly on the issue of whether the Council is able to demonstrate a 5-year supply, whilst the requirement for the purpose of that calculation is derived from the standard method. The standard method does not specify the requirement or displace that which is specified by the development plan as a measure of need over the plan period. The relevance of the policies is entirely contextual, and CS32 is not relevant at all. Its purpose is to provide criteria for the assessment of sites that are brought forward for development in service villages through the development management process, and to require that schemes of more than about 25 dwellings are allocated through the development plan process. Since none of the policies are most important, the question of whether they are out of date does not arise. Therefore, the tilted balance will only operate in this case if the appellant is able to establish the Council cannot demonstrate a 5-year housing land supply. So, turning next to conflict with the development plan, I am not going to read out the relevant legal principles because I think, sir, you are entirely familiar with them. I hope that as I make the remainder of my submissions on the development plan, the individual points that you see set out there in paragraphs 1 to 7 will resonate with some of the principles, well, all of the principles I set out. That's the point. They're contextual, and you'll see, I think, in a moment, sir, how they bear upon what I've got to say. Beginning with the development plan, I'm not going to read out what its components are because you know. Turning to paragraph 32, As I've noted, the most important policies for determining this appeal are CS4, 5, DN8, DM10, DM32 and SA1. CS16 ought to be added to the list in the light of the need for affordable housing in North Somerset, and the proposal to deliver a policy-compliant total of 18 affordable dwellings. I should add, sir, there that that's so particularly because Mr Muston agreed it's one of those most important policies. That express concession having been made, I can hardly demur from that. So, next I turn to the issue of, well, what is policy SA1, what does it mean? Now, the site allocations plan specifies how the housing requirement will be met. Some 1,476 dwellings are to be provided in service villages through proposed allocations and large sites of planning permission identified by policy SA1. Table 1 of the site's allocation plan indicates a total of 22,285 dwellings will be provided, which is 106% of the requirement. That's expressed to exclude sites which will come forward through the development management process, including sites located adjacent to settlement boundary of service villages promoted under policy CS32, which, as I've said already, is therefore irrelevant for the purposes of this appeal. In that context, policy SA1 provides residential sites of 10 or more units are shown on the proposals map and set out in Schedule 1, together with any specific site-related requirements or key considerations to take into account. Schedule 1 lists the sites that are allocated by the plan. It sets out the provisions of SA1 in respect of each site under 4 headings. Working left to right, the 4th heading is Site-Specific Details Notes. Policy SA1 allocates Moor Road at Yatton for 60 homes. The site-specific details notes include no development in the orchard, and then the provision of an access road across the orchard will only be considered if alternative access arrangements cannot be made and subject to a suitable scheme being agreed with Natural England. Should a suitable scheme not be agreed, alternative access arrangements must be made. The words of policy SA1 expressly incorporate each of the sites that are identified by Schedule 1 and shown on the policies map, together with any specific requirements or key considerations. Thus, the terms of Schedule 1, including matters listed under the 4th column heading, form part of policy SA1, and that's indicated by 3 things. First, the ordinary natural meaning of the words of SA1 and Schedule 1, read in a common sense way, having regard to the purpose of the policy, which is to secure a satisfactory form of development on each allocated site. Secondly, and more particularly, specific related requirements and key considerations are essentially directive, and thus properly to be regarded as an integral part of the policy, which has been reduced to a policy which incorporates a schedule in the alternative to creating individual policies for the allocation of each site. And thirdly, in accordance with Regulation 8.2 of the 2012 regulations, the written justification to policy SA1 is clearly identified in 10 paragraphs, numbered 4.1 to 4.10. By contrast, Schedule 1 is separate from the written justification and expresses the substance of policy SA1, so as a matter of fact and logic, it must be part of the policy. Turning then to the meaning of Schedule 1's provisions for Moor Road, Mr Muston agreed the words no development in the orchard must refer to housing development to make sense of the subsequent provision about access arrangements. I say that must be right. As to the meaning of the paragraph dealing with access arrangements, the parties agree the provision of a road across the orchard is only permitted, it will only be considered, if a suitable scheme of mitigation is agreed with Natural England and alternative access arrangements cannot be made. Turning first of all to the requirement for suitable mitigation, the question of whether a suitable scheme of mitigation has been agreed with Natural England must be taken to refer to matters that lie within their particular remit as statutory consultee, an expert ecological advisor. In the context of this appeal, that means a scheme to mitigate the impact of development on the Mendip and North Somerset Bats special area of conservation. It cannot reasonably be taken to encompass any wider comments and concerns they might express. Further, a scheme is to be taken to be agreed, I beg your pardon, sir, further, whether a scheme is to be taken to be agreed is not to be judged by the use of any particular words. It is sufficient if Natural England indicate clearly they do not object to the impact of a scheme on the protected characteristics of the SAC. That submission begs the further question: if Natural England agrees a suitable scheme of mitigation, is a developer required to secure alternative access arrangements if they can be made? The Council's case is that they must. This requirement was introduced by a main modification of the SAC following examination. Mr Muston's evidence is that the background to this restriction demonstrates it was not concerned solely with avoiding harm to ecological interests. It was also motivated by concern about the impact of a road on amenity. Since those objects are separate, a proposal of construction of the policy indicates both requirements must be satisfied. Adopting that approach, Natural England has confirmed the scheme will have no adverse effect on the integrity of the SAC, that they do not object to its impact on the protected European site. Therefore, the scheme satisfies the first requirement, but turning to the second, which is alternative access arrangements. The issue whether alternative access arrangements cannot be made is a question of fact. Compliance with this element of the policy requires developers to conscientiously try to secure a suitable access which avoids crossing the orchard. Grange Farm Road and Yatton Rugby Club are alternative accesses. The appellant does not dispute Mr Thorne's evidence that it is technically feasible to access the appeal site from Grange Farm Road. The land is owned by a house builder and has been retained to provide access to it. The appellant does not contend that the use of this site would raise viability issues, nor can it be contended the route is not available. Mrs Ventham's evidence was that she is unaware of any steps that Persimmon might have taken to secure this access. There is also the potential to access the site through Yatton Rugby Club to the northwest of the appeal site. The draft North Somerset Local Plan Preferred Options document actually proposes that the Rugby Club and the appeal site should be developed as a single scheme. However, matters are moving more quickly than that. Strongbox submitted an outline planning application for housing development at the Rugby Club during the first week of the inquiry. That creates a real possibility of securing an access road. However, Persimmon has not pursued this option. Therefore, the appellant has failed to comply with the requirements, show that alternative access cannot be made, and accordingly the proposal conflicts with policy SA1. In addition, the harm the scheme would cause to setting and character of Yatton conflicts with policy CS5, DM10 and DM32. I've said already the scheme would cause the CS4 and DM8 and CS16. But in view of the central importance of SA1, the additional conflict with CS5, DM10 and DM32, the manifest importance of these policies and the clear breach of each of them, which is not outweighed by the scheme's compliance with CS4, CS16 and DM8. You are invited to conclude the proposal does not accord with the development plan read as a whole. So turning to other material considerations, there's 5 of them, sir. I've set them out under paragraph 48, taking them each in turn. Firstly, the 5-year supply of housing with tilted balance. If the Council is unable to demonstrate a 5-year supply of housing, the policy of paragraph 11D of the framework is a material consideration in favour of allowing the appeal. Since the underlying purpose of the tilted balance is to secure the delivery of housing, where it appears provision might otherwise be constrained, the Council concedes that if paragraph 11D is found to apply, it ought to be given significant weight. As for the provision of 42 marked and 18 affordable homes, whether or not the Council can demonstrate a 5-year housing land supply, Mr Muston conceded the delivery of 42 market houses and 18 affordable homes within 5 years in a sustainable location should be afforded significant weight. As for economic benefits, the scheme will deliver those benefits. However, no cogent evidence has been presented on the value of the temporary benefit that will be delivered by construction activities, nor has the appellant evidenced the value of the permanent effect of increased household expenditure on local services and facilities. Certainly there's no evidence that those services and facilities are in decline or that they would benefit materially from the development. Therefore, notwithstanding the framework generally attaches significant weight to the need to promote economic growth and wider opportunities for development, on the facts of this case, You're invited to agree with Mr Muston that they only merit limited weight. Biodiversity gain next. The Council accepts the appellant's revised scheme coupled with the delivery of off-site compensation secured by condition will deliver net gain. That's obviously a benefit. However, it must not be double counted since it's already been placed in the planning balance and the assessment of the scheme's compliance with CS4 and DM8. The provision of policy compliance with biodiversity net gain cannot also rank as another material consideration. And finally, alternative access. The availability of alternative access to the appeal site from Grange Farm Road or the Yatton Rugby Club is a material consideration. Each alternative is technically feasible. There is no evidence from Grange Farm. There is no evidence access from Grange Farm Road would affect the viability or deliverability of the scheme, and it's conceded access through Yatton Rugby Club is less certain would cause delay. The use of alternative access would avoid any harm to the character and setting of Yatton, nor would it prejudice the delivery of the appellant scheme for improving the orchard, which is a necessary component of its HEP and B&G offer. This consideration, therefore, attracts significant weight. So to conclude, the scheme conflicts with the development plan. If the tilted balance is not engaged, the statutory priorities according to the development plan is not outweighed by the benefits associated with the early delivery of 60 market and affordable homes and the unevidenced economic benefits of the proposal. Each of those benefits could be secured by a policy compliance scheme that adopts an alternative and more sustainable access from Grange Farm Road or Yatton Rugby Club, thereby avoiding any harm to the character and setting of the village. And even if the tilted balance is engaged, the Council invites you to conclude that Secretary of State's policy on the 5-year supply and the importance of keeping plans up to date is still outweighed by the potential to secure a policy compliance scheme which better reflects local people's strongly held views on the orchard's contribution to the character and setting of Yatton. For those reasons, sir, we would invite you to dismiss the appeal.
Okay, thank you very much, Mr. Leader. Thank you. Bear with me a moment. Thank you. So, Mr. Banner,
Thank you, sir.
can I...
I've worked in my responses to the text. If you could possibly give us 5 minutes to print it out and save you doing a,
Yes,
a handwritten note of the ad-libs. I thought it was easier.
Let's have a short adjournment. It's 10:07. If you do 10:15, will that have time for that to be printed out?
I think so.
Okay.
It seems to be fast enough. So,
I'll
thank you.
adjourn, then we'll resume at 10:15. Thank you. Well, the inquiry is resumed. Has that been a sufficient adjournment for the printing to take place? Almost. Yeah. Okay. We'll sit quietly then for a few more minutes. Lovely, thank you.
You can... In which case, so if you're ready for me to
Yes, when you're ready,
start.
Mr. Banner.
So a few words first by way of introduction. Following the Council's confirmation that it no longer maintains any ecological objection to the development, either in the form of reasons for refusal or in the form of a material consideration, the issues in this appeal have considerably narrowed. And we say it's now entirely clear that the development is in accordance with the development plan. And as such, this is actually now a very simple appeal to decide without even needing to delve into consideration of five-year housing land supply or whether the most important policies for determining the appeal are otherwise out of date. And in section 2, I explain why, if you like, the path of least resistance route according to the plan as a whole. But in the event that you were to disagree and consider that the proposed development isn't in accordance with the development plan, there are compelling reasons for concluding that the tilted balance is engaged on either or both of the two grounds we advance, five-year supply or most important policies. It's now common ground, there's no clear reason for refusing development, so 11D1 is not an issue. And given that no ecological objection is maintained by the Council, given that the character objection relates only to the unlit access road in the southern field, where there'll also be considerable new planting, including the restoration of the unlit orchard, and it's not an objection to the housing, it's clear beyond doubt that the adverse impacts of granting permission don't significantly demonstrably outweigh the benefits for the purpose of MD2, and we put that part of the analysis in section 3. So then turning to section 2, and is the proposed development in accordance with the development plan? Answer, we say yes. I start so with policy SA1. And schedule 1 of the site allocations plan, the SAP, sets out 11 what are described in the table as site-specific detailed stroke notes in relation to the allocation of the appeal site. And of these, the remaining objection by the Council relates only on the third, and therefore it must be inferred that it's agreed that there's compliance with the remaining 10, as Mr. Muston confirmed. And with the third of the relevant details notes says the provision of an access road across the orchard will only be considered if alternative access arrangements can't be made. I say that's element 1 of this provision, and subject to a suitable scheme being agreed with Natural England, element 2. And Mr. Muston rightly accepted in cross-examination that the non-objection from Natural England would equate to agreement for that purpose, and of course that is the current position, as both parties agreed in relation to the scheme of mitigation proposed by the appellant, and I note Mr. Leader's closings helpfully confirm at paragraph 42 that the Council agree you can proceed that the suitable scheme agreed with Natural England element of this detailed stroke note has been complied with. Therefore, the only remaining dispute relates to just one element of this detailed note, namely the words, if alternative access arrangements cannot be made. And as to this, we make the following submissions. So firstly, we say that the officer's report was right to conclude that alternative access arrangements cannot indeed be made. So we comply with this consideration. And as to this, I make a number of points. Firstly, it's common ground that if the appeal fails, on the basis that access via the orchard is not acceptable, this allocation won't be deliverable within the Council's 5-year housing supply, and thus wouldn't be deliverable within the SAP plan period, which runs to 2026. And it's also common ground, as Mr. Muston agreed in cross-examination, that in that situation, the objective of the SAP in relation to the appeal site, i.e. the delivery of the site for housing within the plan period, would not be achieved. And so what we say is that one has to read the provisions of Schedule 1 in the context of the objectives of the SAP and its plan period. So in other words, the reference to if alternative access arrangements can't be made must be taken as meaning if alternative access arrangements can't be made within the plan period, reading it in context. And the contrary reading, namely that if it might be possible to make alternative access arrangements at some later indeterminate point in the future, then the delivery of the plan within the delivery allocation of the plan period could be thwarted, would be absurd. It would defeat the objective. I mean, if there's no time limit, then you could defeat the allocation by saying, well, alternative access arrangements could be made in 2247. I mean, that's just nonsense, absolute nonsense. So one has to read it in the context of the plan period, i.e., if alternative access arrangements cannot be made within the plan period, and it's agreed, they can't. End of. End of. The proposed development of the rugby club is currently not in accordance with the development plan. The emerging new local plan is still at an early stage, and it's agreed that it can only carry little weight. It was said during the inquiry an application has been submitted. As of yesterday, there was nothing to this effect on the council website. That may have changed this morning in the last few minutes, but it doesn't matter, because in any event, it's far from clear that the applicant intends to progress an application to determination, as opposed to using it as a device to support the proposed allocation, as is common practice in such situations. Even if permission were to be granted in the near future, which seems unlikely at best, given that the site is in use as playing pitches, currently afforded protection under the local plan. But even if it were to be granted permission, it will be years before the site becomes available, because a new home for the rugby club has to be identified, consented, and made ready with the laying of pitches and letting them bed in before the redevelopment of the site can even start. And notably, the council itself accepts that the rugby club site can't form part of its 5-year supply. As to access via Grange Farm Road, that can't be made because the adopted public highway doesn't go to the boundary with the appeal site, and that's a situation entirely of the council's own making, as Mr Thorne accepted in cross-examination by reference to the adoption plan. The council has itself described the situation as a potential ransom scenario, and the fact that it accepts that the appeal site wouldn't be delivered within 5 years if access via the orchard isn't allowed is indicative of the multiple uncertainties associated with the ransom scenario. Whilst the highways experts have agreed that access via Grange Farm Road is feasible in high engineering terms, and ditto ultimately the rugby club once it's, if and when it happens, that misses the point, because as Mr Musson accepted, the words "if alternative access arrangements can't be made" are concerned with more than just feasibility in engineering terms. Deliverability is plainly a critical part of consideration. Notably, the council itself accepted that policy SA1 was fully complied with when it refused permission for the earlier scheme, because the policy wasn't cited in its reasons for refusal, and I have a bit of elaboration of that in the footnote. Nothing material has changed then in relation to either candidate alternative access. And Mr Musson accepted in cross-examination that the council's stance in relation to the present appeal isn't consistent with the stance taken in the earlier scheme, and he was unable to offer an explanation for that inconsistency. So for all those reasons, sir, we say that the proper conclusion is alternative access arrangement cannot be made, and therefore there is complete compliance with Schedule 1, and therefore even on the council's case that complete compliance with Schedule 1 is necessary to avoid conflict with SA1, that's been achieved. There is therefore no conflict. If you don't accept that analysis, then we say the following in the alternative. If you were to disagree and find that it hasn't been shown that alternative access arrangements cannot be made, we say we're still in accordance with the development plan for the following reasons. First, complete accordance with Schedule 1 isn't obligatory to achieve compliance with SA1. And for this, we say the following, that the site-specific details and notes aren't part of the bold text policy. I mean, it's clear that the bold text policy is denoted in the yellow boxes. SA1 is on page 14, and it describes the contents of Schedule 1 as things to take into account, not mandatory criteria. I don't deny there's a link, because obviously that's what the yellow text says, but take into account is the critical words. Secondly, the appeal scheme is agreed to comply with 10 of the 11 site-specific details notes, as well as half of the remaining one. It's clear from the reference to the need for a scheme to be agreed with Natural England that the sole, or at least primary reason for the proviso, if alternative access arrangements can't be made, was that the orchard was considered to have ecological value, which could be harmed if the access road was to go through it. This provision is all about protecting the ecological value of the orchard. And it's now agreed, however, that there are no ecological grounds for objecting to the access road, and that the proposed development will be acceptable in ecological terms. So the objective of this provision, ecological protection, has been complied with. Secondly, if you aren't with me so far, so you think there is non-compliance with alternative access arrangements can't be made, and that leads to conflict with SA1, if that's where you've got to, then we say that still doesn't preclude a conclusion that the development is in accordance with the development plan as a whole, given in particular the following. Firstly, Mr Muston accepted very fairly on behalf of the council in cross-examination that complete compliance with the considerations of Schedule 1 wasn't necessary to achieve accordance with the plan as a whole, applying established principles. Secondly, any conflict is limited, half of one of the 11 detailed stroke notes. Thirdly, as I've indicated before, the sole or main objective of the relevant provision, which was ecological related, has been complied with because the Council now agrees the development is acceptable in ecological terms. And in this respect, sir, the present case is analogous to the SOEM appeal. So we couldn't find the inquiry document reference, and we looked, but we couldn't find it. You know the one I mean.
Yeah, it was handed in as a document.
That's right. That was the one where Inspector Boniface found accordance with the plan as a whole, despite conflict with a policy called Growth 2, the sort of don't develop outside the settlement boundary type policy in the East Cambridgeshire local plan. And the reason he found accordance with the plan as a whole, despite the conflict with that policy, was because the objectives of that policy weren't undermined. In that case, there was no issue with BMV, no issue with landscape, no issue with the other sustainability. So all the things why you might have a policy like that weren't undermined, and therefore the objective of the policy wasn't undermined. Therefore, he found compliance with the plan as a whole. And we say, well, that's quite similar. If you do think there's conflict, let's say one, because of the alternative access issue, then you go to, well, is the objective of that undermined? And we say, no, it's not. And then further, if the proper conclusion is that alternative access arrangements can't be made, there's a tension between that provision and the SAP objective of delivering the allocation within the planned period. So this is a paradigm case of the plan pulling in different directions. And in the circumstances, we say greater weight should be given to the latter consideration, delivering the allocation in the planned period, because that's fundamental. That's what the whole point of the SAP was about, delivering the allocations within its period. Whereas insisting on the alternative access, when the proposed access is acceptable in ecological terms, and in fact delivers certain benefits I'll come on to deal with, isn't fundamental. And so add this also that it was highly telling that the Council's closings don't actually contend that the alleged breach of SA1 that they contend for would on its own justify the conclusion that there's non-accordance with the plan as a whole. The Council's closings only allege non-accordance with the plan as a whole based upon the alleged additional conflict with the landscape, etc. related policies due to the character and appearance point. And we say there's no additional conflict, the reason I'm going to turn to now, and therefore on the Council's own case, it's SA1 alone, and that doesn't generate non-accordance with the plan as a whole. Let me turn then to character and appearance, and I'll say that's the Council's remaining objection, and it's without merit. The starting point for considering this issue is that the Council's objection relates only to the access road and the hogging paths in the southern field. There's no character and appearance objection in relation to the housing in the northern field. And secondly, the Council hasn't called any expert evidence on landscape or townscape character and visual impact. The attempt to draw a distinction between landscape, townscape, character and visual impact on the one hand and character and appearance on the other hand is, with great respect, pure semantics, and it should be rejected. Mr. Jeremy Smith's expert evidence in relation to the development's effects on landscape character and its visual effects were largely unchallenged in cross-examination, and for this reason, and in any event, as the only expert evidence on this subject before the inquiry, his analysis should be accepted. His conclusions are that the overall landscape and visual effects of the access road, and his words, would be highly localised and focused on an area which is already recognised as being strongly influenced by the settlement. He also said that the alternatives suggested by the Council, which tellingly they accept would comply with the development plan policies, would also result in localised negative landscape and visual effects, i.e. we do no worse, in his view, than the alternatives which they say comply. But it's not just a question of doing no worse, because unlike those alternatives, the appeal scheme would deliver the replanting of the orchard area, which, in his words, would result in some important landscape and visual benefits, and would create a distinctive place in keeping with the character of the area. The reference in the reason for refusal to rural character is misconceived, because the appeal site, including the orchard, is classified within the Council's own landscape character assessment as settlement. And that's corroborated by Mr. Smith's explanation in his rebuttal of the sequential experience of entering Yatton, which Mr. Muston accepted in cross-examination. This was accurate. Further and really fundamentally, the uncontested baseline is that all the remaining orchard trees on the appeal site will fall, if they haven't already, and die within around 10 years, with no plan for succession. And as Mr Muston accepted in cross-examination, this might mean that in the baseline scenario, the southern field will be just a privately accessed paddock with some fallen decaying trees. In contrast, the appeal scheme would deliver the restoration of the orchard with new apple trees, a wildflower meadow, together with measures to ensure that the 4 veteran orchard trees that are still standing remain upright in the future, thus preserving their contribution to character, as well as the ecological value of their dead heartwood, which would be lost if the trees fall over and the wood becomes damp. And on any view, that's a considerable benefit to the character and appearance of the locality. The restored orchard will be a publicly accessible community asset, enjoyed and valued both by the residents of the appeal scheme and by those living in the existing properties in the area. And Mr Muston rightly accepted in cross-examination that there's no evidence that the restoration of the orchard would happen in the absence of the appeal scheme. It's certainly not a requirement of SA1 or Schedule 1, and it's not something, therefore, that could be required of an alternative scheme that went via the Rugby Club or Grange Farm Road. Mr Phillips has initially questioned whether new planting would be successful or whether it would require restriction of access to restored orchards, various points made there, but that was comprehensively rebutted by Mr Smith in his rebuttal. He wasn't challenged on this in cross-examination. I'm not sure that's a contested point anymore, but in any event, Mr Smith's evidence should be accepted for those reasons. Turning to ecology, it's now common ground on both sides of the room that the proposed development wouldn't have an adverse effect on the integrity of the SAC. Subject to conditions, it would deliver a net biodiversity gain and would all in other respects be acceptable in relation to ecology and biodiversity. In fact, the position goes further than that because, as Mr Clarkson's evidence has explained, the scheme will actually deliver important ecological benefits. Chief amongst these are 260 metres of new species-rich hedgerow, well in excess of the 50 metres to be lost, and the restoration of the orchard, I've described a moment ago, alongside the retention of the veteran trees currently on site, and in particular the measures taken to keep the 4 still standing veteran trees upright in perpetuity compared to the baseline, again, I've just described, where they're going to fall over and die within around 10 years. And the particular significance of this in ecological terms is that the trees that will be kept standing as opposed to being allowed to fall include the one that hosts the exceptionally rare orchard tooth fungus. In the baseline scenario, it's clear the orchard tooth fungus won't survive on site beyond about 10 years because once this host tree falls, the dead heartwood will become too moist to host the fungus. The scheme is therefore the only opportunity for the planning system to ensure that this tree remains standing in the long term. And by co-locating the new orchard trees alongside it, the opportunity is presented for the fungus to propagate into new host trees. And that's precisely the same strategy you might recall we heard on the first day Yakwag have adopted on the other side of the road, and have a little plaque to explain that. So in conclusion, sir, the scheme complies with all relevant policies in relation to character and appearance, landscape and ecology. It's also in complete accordance with SA1, but even if you were to find there's some limited compliance with SA1 in relation to alternative access, for the reasons given, the scheme is nonetheless plainly in accordance with the development plan as a whole. And if you're with us on that, that's the end of the matter. No one suggested that if the scheme is found to be in accordance with the plan, through material considerations indicate otherwise and justify refusal. Therefore, it's 11C territory. The scheme should have been approved without delay. And unless you really wanted to, you don't need to get into housing supply or most important policies or anything like that. That's just the end of the matter. Turning into section 3, if you're not with us so far, so you think there is a non-accordance, so there is a need to think about 11D, we say that the tilted balance is engaged for either or both the 2 reasons I've foreshadowed. I'll deal with 5-year supply first. And we say it's plain that the council can't demonstrate a 5-year housing land supply for the reasons given by Mr Patterson-Neild. For the sake of brevity, as we had a specific session, you've got particular, I'm just not going to repeat those. I'll incorporate them by reference, but make a few critical observations. I mean, overall, the headlines, in light of the addendum statement to Common Ground on housing supply, is the respective positions are now 5.2 years alleged by the council, which, even in their case, that's a precarious, quote, surplus of only 291 dwellings, compared to 3.1 years, which, if that's right, is a severe and, on any view, highly concerning shortfall of over 2,800 dwellings. And the golden thread running through the lion's share, not all, but the lion's share of the debate between the two experts on this issue is the Council's failure to provide the necessary clear evidence in relation to major developments which don't yet have full permission or reserve matters. The Category B sites, or the ones that are not in either category, but nonetheless relied upon. And the Council's case in relation to the disputed sites falling into this description was founded on a combination of speculation, inference and anecdote, which falls far short of the evidential standard required by the framework definition of deliverable. And so too, in terms of falling short, is a repeated mantra that Miss Richards knows her patch. She may do, as one would expect any local authority officer would do, but the MPPF requires more than that for the disputed sites to be shown to be delivered. I mean, if it were otherwise, all a local authority would need to do is say, my officer knows their patch, go away. But plainly, the MPPF requires greater interrogation than that. Further, the approach of the Council's closings, with great respect, of framing the question as which party's assessment is most likely to be correct, with respect, is misplaced. Because in relation to major developments that don't yet have full permission or reserve matters, the onus is much more firmly on the Council. The question is whether they have provided the necessary clear evidence. If the Council can't demonstrate a 5-year supply, it follows under Framework 11D and footnote 8 that the most important policies, including SA1, are deemed irrefutably to be out of date, which necessarily reduces the rate to be given to any conflict. Second point, is the basket of most important policies otherwise out of date anyway, irrespective of 5-year supply? And again, we say yes. The differences between Mr Must and Miss Ventham on this issue were actually very narrow indeed. Mr Must's sole point was that policy CS13 of the core strategy, which he accepted was out of date, wasn't one of the most important policies. He didn't take any other issue in his evidence with Miss Ventham's characterisation of the basket as set out in that table with the yellow markings in her proof, or with her view as to which ones were and weren't up to date and out of date. And Mr Ruston's position on CS13 was that because that policy sets out a housing requirement which is no longer the relevant figure for 5-year supply purposes because it's been overtaken by the standard method being more than 5 years old, because of that, it's not a most important policy. And as he ultimately, I think, did recognise in cross-examination, there's a difficulty with that analysis, a circularity, because it equates to saying the policy can't be a most important policy because it's out of date. Now, in the context of Framework 11D, where the tilted balance applies when the most important policies are out of date, that analysis is obviously untenable because it means you can never surmount the threshold, because if it's out of date, it can't be an MIP. It's unworkable when one thinks about it, even for a moment. And it's also inconsistent with, again, Inspector Boniface's decision in Soham, where he endorsed the party's view. And it was common ground, to be fair, but he does, in the decision at 20, endorse the common ground. The policy growth 1 of the East Cambridgeshire plan, which was the equivalent to CS30 in that case, the requirement figure, he endorsed the view that that was the most important policy. That was out of date because it had been superseded by the standard method as the relevant figure. So precisely the same situation. Requirement figure superseded, most important policy and out of date. Accordingly, the sole basis by which Mr Muston disputed Miss Ventham's opinion that the MIPs are out of date, it is without merit. Now, in cross-examination of Miss Ventham, Miss Leader went a bit beyond the Council's evidence, the single point taken by Mr Muston, and he questioned Miss Ventham's analysis that CS14 was out of date. That's plainly incorrect because, as Miss Ventham explained when dealing with this line of questions, CS14 is the policy for distributing the out-of-date requirement figure in CS13, and as such it's necessarily infected by the out-of-datedness of the policy it seeks to give effect to. And essentially the same analysis again was adopted by Inspector Boniface in Soham in relation to growth 2 and growth 4, actually as well, of the Cambridgeshire local plan, which were predicated on the out-of-date requirement. He says that in terms. In fact, the word infected, I think, was, I've nicked from him, actually, I think, that he might have nicked from me in that case. The cross-examination of Miss Ventham in relation to the other policies that she considers are her most important policies and out of date was largely exploratory, asking why she'd reached that view, as opposed to challenging her analysis, which in any event would have been improper given that there was no evidence from the Council contradicting her analysis. But further, the cross-examination appeared to proceed on the assumption that only controversial policies, i.e. ones in relation to which it's alleged there's a breach of, can be most important policies. And that line of argument was repeated in the Council's closings. But there's no basis in the framework or case law for saying that to be a most important policy, you have to be in the reasons for refusal. A policy can be important, very important, even if a proposal complies, not least because it could give important support to a development. And again, the appellant's case in this respect is consistent of that with respect to Boniface and Soham. He described the litmus, if you like, of a most important policy as being whether it related to whether the proposed housing development is acceptable in principle. Curiously, and it may have been my misreading, but the paragraph 28 of the Council's closing appeared to suggest there aren't any most important policies. If that is the suggestion being made, that does demonstrate the Council's case on this issue is threadbare. Turning then to the benefits in tilted balance context, they're wide-ranging and compelling. The full list is set out by Ms Ventham. I draw particular attention to the following ones which are included within that list. Firstly, the contribution to the Council's pipeline of deliverable housing supply in circumstances where, on the Council's own case, the supply is precarious, on our case it's dire. Secondly, securing the delivery of the allocation within the planned period, the only way that can be secured. Thirdly, 18 affordable homes in circumstances where affordable housing delivery has been significantly below what's required. Fourthly, the significant economic benefits outlined in Appendix 7 of Ms Ventham's evidence. Mr Munson accepted in cross-examination that the appeal scheme would in this respect support economic growth and productivity, and accordingly, if paragraph 81 of the framework were to be applied, significant weight should be given. His approach, reiterated by Mr Leader, was that paragraph 81 shouldn't be applied. But we say there's no tenable basis for departing from national policy here. And indeed, can I just add in parentheses, of course, in the tilted balance context, you're told to have regard to the policies in this framework. That's what 11D2 says, doesn't it? And so therefore, by definition, one has to have regard to 81. You can't ignore it. Then the fifth point, the ecological enhancements, which I've described above, particularly the orchard truth fungus issue, which is of national importance, and sixthly, the improvements to landscape character and appearance arising from the orchard restoration, the wildflower meadow and the associated recreational benefits by making this revitalised community asset publicly accessible. And then turning to the adverse impacts, well, really on the Council's own case, it boils down to what is truly minimal, namely the alleged effect on character and appearance of the access road and the hogging paths alone, not the housing, on character and appearance. And that's it. So, in conclusion, it being common ground that there's no clear reasons for refusing development, no showstoppers that displace the tilted balance under 11D1, because there's no issue on ecology, and the Council accepts that in relation to heritage, the lower end, less than substantial harm, which would occur anyway from the housing in the northern field, is outweighed by public benefits. So we're into 11D2 if the tilted balance applies, and we say on no tenable view of the claimed adverse impacts of such a nature and extent to significantly demonstrate outweigh the benefits. The purpose of 11D2, the balance of benefits versus harm, lies firmly in favour of granting permission. And even if you find there's non-accordance to the plan and the tilted balance doesn't apply, so even for a straightforward Section 38.6 flat balance territory, even in that scenario, there are compelling material considerations here which would justify the grant of permission, essentially for the reasons I've given. So, sir, putting all that together, in my final remarks, I say, well, whichever way one looks at it, and ultimately whichever way you decide to look at it, the case for granting planning permission really is overwhelming here. It's in the public interest to allow this allocated scheme to proceed, and so we respectfully invite you to allow the appeal. Those are the closing submissions.
Okay, thank you very much, Mr. Banner. Thank you. Right. So, just a couple of things then, please. The note of the qualifications.
Why not? Something to do on the train.
Thank you very much.
Thanks, Tim.
That's good, thank you. Can I also ask that electronic versions of your closing submissions be sent through to the Inspectorate's case officer, please? And just confirmation that the version of the signed version of the Section 106, I'll tell the Inspectorate's case officer to expect it within 7 days, but as you've indicated, it should be much sooner than that. Thank you. And can I have the attendance list back for today, please, if everyone's signed it? Have we all? Thank you. So before I close the inquiry, just to check any applications from either side.
Not from me, sir.
No,
Thank
sir.
you very
Can I thank you for hosting the inquiry and for your patience? And also thank you to the people who've been involved with the live stream. We were saying actually last night how effective the live streaming and the tech has been.
Yes, it's worked well, yeah. Thank you. Well, on that note, then, all that remains is for me to thank all parties for the helpful way you've conducted yourselves during the proceedings, and the inquiry is now closed.
Thank you.
Thank you.